From Kentucky, Mr. Massie, and a member opposed. Each will control 5 minutes. The chair recognizes the gentleman from Kentucky.
Mr. Chair, I rise in support of my amendment, which states none of the funds made available by this act may be used to conduct a competition analysis when evaluating mergers. Beginning in January 1 of 1989, Congress vested primary authority to review airline mergers with the U.S. Department of Justice. Since that time, the Department of Transportation has deferred to DOJ to determine whether a merger between U.S. airlines should be challenged on competition grounds. The Department of Transportation's General Counsel under President Obama described the DOT's role in airline mergers as follows. Quote, with respect to DOT's competition and public interest review authorities, DOT's practice has been to use its expertise with respect to the airline industry to provide the department's views and otherwise assist the DOJ in DOJ's analysis of airline mergers or acquisitions, end quote. The Department of Justice recently challenged an airline merger. Now, this amendment doesn't have anything to do with that court case. In fact, it's well within DOJ's rights and authority to challenge mergers. But what concerns me is that the DOT Secretary Pete Buttigieg expressed publicly that his department, quote, has generally not gotten involved in these mergers cases, but that's changing today, end quote. Between 2009 and 2016, under the Obama administration, there were 9 successful airline mergers. In fact, in over 30 years, the DOT has not prevented the transfer of operating certificates for any airline merger. This begs the question, why now? I urge adoption of this amendment, and I reserve the balance of my time.
The gentleman reserves. For what purpose does the gentleman from Illinois seek recognition?
Mr. Chair, I claim time in opposition.
The gentleman is recognized.
Let me begin by saying that sponsor of this amendment, I believe, is on the T&I committee, which is the authorizing, has jurisdiction over aviation and rail. This is an amendment which would be better off being moved forward as an authorizing proposal rather than going forward as an appropriation amendment. But this amendment makes it plain as day that the Republicans are happy to put the interest of big corporations ahead of protecting the American people from corporate greed that increases costs, reduces quality of service, and limits options. Specifically, it prohibits any funds for conducting a competitive analysis of mergers, which raises concerning implications for both airlines and rail. The Department of Transportation is required by law to certify that Congress that an approved airline merger is in the public interest and provide an analysis of the effects of the merger on competition in the domestic airline industry. Congress itself has set forth in law a list of factors that are considered in the public interest, which includes several related to competition. Yet this amendment would prohibit the Department of Transportation from complying with that requirement and from even conducting an analysis or considering factors Congress has specifically identified as important, shirking all responsibility to the public interest. At the same time, this broad amendment would implicate all THUD agencies, also impacting competition in the rail industry and our understanding of competition in the housing market. The Surface Transportation Board has authority over railroad corporate mergers and acquisitions, and similarly may approve such mergers only when it finds them to be in the public interest. This requires evidence that the proposed merger will affirmatively enhance competition, efficiency, and quality of service. This amendment ties the hand of the agency with exclusive merger jurisdiction involving railroads, even as the number of Class I railroads has fallen from 40 to 6 since 1980. Further, the Department of Housing and Urban Development would be prevented from conducting any competition-related analysis to inform our understanding of rental markets, even as Americans face rising rents and corporate landlords are caught price fixing. Competition is critical to protecting consumers from corporate greed and fostering a flourishing market economy, something we should all fight for. I urge my colleagues on both sides of the aisle to reject this misguided amendment, and I reserve.
The gentleman reserves. The gentleman from Kentucky is recognized.
At this point, I would like to yield 2 minutes to my friend across the aisle, the ranking member of the Judiciary Subcommittee on the Administrative State Regulatory Reform and Antitrust, Mr. Correa from California.
The gentleman is recognized.
Thank you, Mr. Speaker. Mr. Chairman, I rise today in support of Mr. Massey's amendment, which prohibits the Department of Transportation from expediting funds to conduct competitive analysis of mergers. In 1989, Congress transferred authority to review airline mergers to the Department of Justice. 35 years of DOT policy is clear. DOJ has the leading role in reviewing proposed airline mergers. And given this statutory authority to enforce the antitrust laws, this is consistent with Congress's authority determining that deregulated airline industry should generally be subject to the same applications of antitrust laws as other unregulated industries. I must say that as ranking member of the Antitrust Subcommittee, I am committed to protecting consumers, competition, and innovation. But before the DOT moves ahead with this new unprecedented approach, we must take time to evaluate its merits, and this amendment does exactly that. Give us time to see what's going on. I urge my colleagues to support this amendment.
The gentleman from Kentucky reserves. Gentleman from Illinois.
Mr. Chairman, I reserve.
Gentleman reserves. Gentleman from Kentucky.
May I inquire as to how much time I have remaining?
Gentleman has 1.5 minutes remaining.
At this point, I'd like to yield 1 minute to my colleague, Mr. Rutherford from Florida.
The gentleman is recognized.
Thank you, gentlemen, for yielding. And I rise in support of this amendment. And I really want to reiterate the fact, the point that was just made, that this is such a break from the norm in evaluation of these antitrust analysis going forward. DOJ's had that responsibility. I particularly want to thank the gentleman for the really staying on top of this. This is clearly an overreach by the Biden administration, and I want to thank you for that, and I yield back.
Reserve.
The gentleman from Kentucky reserves. Gentleman from Illinois is recognized.
Mr. Chairman, I'm not sure how to phrase this, but I'd like to ask the sponsor of this amendment through the chair a question. I believe he referred to the Secretary of Transportation's name. I wasn't sure I heard that correctly. If you could ask the sponsor if he would repeat how he referred to the Secretary of Transportation, because the acoustics aren't always great here. I want to make sure I got it right.
Is the gentleman yielding?
Yes. Well, I would reserve. I'd like to ask the question through the chair.
The gentleman reserves.
I reserve.
Gentleman from Kentucky is recognized.
Is the gentleman prepared to close?
I'm prepared to close. I'd still like to make sure I heard what I thought I heard correctly.
I reserve.
Gentleman reserves.
The gentleman reserves. The gentleman from Illinois is recognized and has the right to close.
Gentleman from Illinois is recognized and has the right to close.
Okay, Mr. Chairman. I assume that's the answer is that the sponsor doesn't want to repeat what he may have said. I just didn't hear it, and at this point, I'm prepared to close, and I yield back.
Gentleman yields back. Gentleman from Kentucky.
Well, as a member of the Transportation Committee, I had the honor to question Secretary Buttigieg on whether he had this authority and what metrics he would use to exercise this authority. And it was obvious that they don't have any experience in the DOT to review these mergers because they haven't done it. And so it is for that reason that I urge adoption of this amendment. We don't need redundancy among the departments, and we need an all-of-government approach, and that's what this amendment seeks to do, and I urge adoption of this bipartisan amendment.
The question is on the amendment offered by the gentleman from Kentucky. Those in favor say aye. Aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment is agreed to.
Mr. Chair, I demand a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Kentucky will be postponed. It is now in order to consider Amendment Number 60, printed in Part B of House Report 118-261. For what purpose does the gentleman from Kentucky seek recognition?